Welcome to the Law in Context podcast, Season 2.
We're the two Steves. I'm Emeritus Professor Stephen Bottomley.
And I'm Emeritus Professor Stephen Parker.
We have both been deans of major law schools, and we collaborated on the first two editions of a book called Law in Context.
These podcasts explain fundamental legal concepts in an accessible way.
Whether you are a member of the public wanting to know more about law and make sense of what is in the news,
Or you're thinking of studying law,
or you are already a lawyer looking for a refresher course,
this podcast is for you, with transcripts and more about us, two Steves, on our website at lawincontext.com.au. Should you be allowed to sue a judge for damages if you think they got it badly wrong? We mentioned this issue briefly in our episode on judges, where we said that a judge is immune from being sued for any decision they make as a judge, but there were some loopholes, and occasionally the issue is still litigated.
Well, it was litigated all the way to the High Court of Australia recently. In a significant decision handed down in February 2025, Australia's most senior judges said that the immunity of a judge from being sued for acts in the performance or purported performance of the judge's functions is absolute. It applies everywhere, all the time.
A couple who, for the purposes of the case, were given the names Mr. and Mrs. Stradford, were going through a divorce and property dispute. Judge Salvatore Vasta, in what was then the Australian Federal Circuit Court, ordered that Mr. Stradford should make full and frank disclosure of various financial documents. The matter came back to court several times because Mrs. Stradford claimed that the disclosure was not complete. Finally, the case returned to Judge Vasta, who adjourned it for a short period to allow the parties to discuss settlement. And presumably to give Mr. Stradford something to think about, he said that he hoped Mr. Stradford had brought his toothbrush with him. Mrs. Stradford repeatedly said that she didn't want him to go to prison.
No settlement was reached, and later that day Judge Vasta sentenced Mr. Stradford to 12 months imprisonment for contempt of court in disobeying the disclosure order. In doing this, Judge Vasta mistakenly assumed that a different judge in an earlier hearing had already decided that Mr. Stradford was in fact in contempt of court. Mr. Stradford appealed, and the full court of the family court allowed the appeal, concluding that the process employed by Judge Vasta was so devoid of procedural fairness and the reasons for judgment so lacking in engagement with the issues of fact and law to be applied that it would be an affront to justice to permit the contempt declaration and the imprisonment order to stand.
Armed with this finding, Mr. Stradford sued Judge Vasta for damages for false imprisonment. This is a tort or civil wrong like negligence, defamation and trespass. He also sued the police officers and the correctional officers involved in taking him away and incarcerating him, and the employers of the judges and officers as being vicariously liable for the torts of their employees.
Judge Vasta appealed on the basis that he was immune from being sued. His argument takes us briefly into an arcane area. The judge who awarded damages to Mr. Stradford regarded the Federal Circuit Court, where Judge Vasta had ordered that Mr. Stradford be imprisoned, as an inferior court. The distinction between an inferior court and a superior court emerged in English law in the 1600s, as more courts were set up to deal with local or specific kinds of cases. The jurisdiction or scope of an inferior court was limited in some way, whereas a superior court could hear all matters.
One consequence, in English law at least, was that if a judge of an inferior court made an error and exceeded the court's jurisdiction, whatever that was, the judge was not immune from suit because the decision was invalid from the start. The judge was not actually performing a judicial duty. In contrast, a superior court judge's immunity from civil claims was always absolute, irrespective of any mistakes they made. They were answerable only, and I'm quoting, to God and the King.
For the first time in Australian law, the the High Court had to decide whether a judge's immunity from suit was absolute in all situations, irrespective of which court they were in. It was also an opportunity to go into the arguments for and against judicial immunity, which all come down to public policy. You're listening to the Law in Context podcast by the two Steves.
Remember to rate us on the platform you are using.
Now, back to one of us. Judicial immunity, the High Court found, was absolute, and the distinction between an inferior and a superior court is irrelevant, if indeed it should continue to exist at all. It did find that Judge Vasta's decision to imprison Mr. Stradford was invalid, but it was nevertheless a purported exercise of the judge's power, and that was enough to attract immunity.
Two key reasons of public policy underpinned the reasoning. Immunity from being sued helps protect judicial independence. That independence includes independence of thought. If at the back of their mind a judge thought they might be sued for damages should they make a wrong decision, they might be swayed by that rather than objectively and impartially applying the law to the facts. Although not mentioned by the High Court, perhaps it was acknowledging that some parties are well-resourced and always ready to go to law. If faced with a litigious and wealthy party, lack of immunity could lead to a bias in that party's favour.
The second key reason was to achieve finality and, quote, quell disputes. This is a known value in legal systems. For example, there are usually limitation periods in civil law matters and sometimes in criminal law ones. If a case is not brought within a stated period of the cause of the case, the defendant can plead that the case is time barred. Judicial immunity promotes finality in bringing an end to things. An unsuccessful party can appeal against an initial decision, but once all appeal avenues have been exhausted, that is that.
The High Court noted that there are constitutional powers for parliaments to remove judges for misbehaviour and incapacity, and if the judge has committed a crime, for example taken a bribe from one party, then the criminal law can be applied. But in the more likely case where the unsuccessful party argues there's been a mistake, or even that the judge was motivated by bias or malice, the only recourse is to appeal. They can't sue the judge. So firm was the High Court in its reasons that contrary arguments barely see the light of day.
An obvious counter-argument is that the removal of judges by parliaments for misbehaviour is extremely rare. It is not a practical course of action by a disappointed litigant to petition Parliament, and it doesn't compensate them anyway.
And appealing against a decision is very expensive, not open to most people, particularly with the near disappearance of legal aid schemes in civil matters. In other professions, public indemnity insurance exists. Judges' insurance, if it were introduced, could mean that normally the judge would not pay the damages personally if they could be sued. And if the judge couldn't find insurance, perhaps something about them needs looking into.
In principle, compromise solutions could be found. A hurdle might be put in the way of someone who wants to sue the judge in their case. The plaintiff might have to obtain permission or leave to bring the case. They might have to show malice on the part of the judge or an error so extreme that the judge had been reckless, not merely negligent.
But courts are different from, say, private arbitration. Litigants do not make a contract with courts and are not consumers of a court's services. They are engaging in a public process where there are public interests at stake.
Having said all this, the public policy arguments so resoundingly affirmed by the High Court are completely bereft of any data about what the public actually thinks or might think if the arguments and counter-arguments were presented to them.
None of this has improved Mr. or Mrs. Stradford's financial position, and no one is going to compensate them.
And what of the police and correctional officers? They were immune too, because they were entitled to rely on Judge Vasta's decision.
Courts are, in a very real sense, a law unto themselves.
Did I tell you that a student once tried to sue me for negligently giving a lecture?
No, what happened?
It failed. I had the perfect immunity because all the witnesses were asleep.
Thanks for listening to this episode, brought to you by The Two Steves. You can find more in this gripping series at lawincontext.com.au or wherever you get your podcasts.
Send us a question or add a comment on the website.
And as Sergeant Esterhouse used to say in Hill Street Blues,
Let's be careful out there.
bye.
Bye.